Chairperson, and good morning to honorable members, the minister, my colleagues. We are all present, Chairperson, except for the judge. Members of the commission are here with me. I am also accompanied by members of the executive team here with the CEO leading that team. Thank you very much indeed.
Thank you. Parliamentary Legal Services.
Good morning, Chairperson. My name is Siviwe Njigala from Parliament's Legal Services. I'm with my colleague, Daksha Kassan. We will be assisting the committee. Thank you very much, Chair.
Thank you very much. State law advisors.
Good morning, Chairperson. Good morning, members, honorable members. Good morning, Minister. Good morning, Commissioners. My name is Suraya Williams. I'm from the Office of the Chief State Law Advisor, and I'm accompanied by my colleagues, Ms. Sada Govinda and Ms. Aisha Jawar. Thank you, Chairperson.
Okay, thank you. All apologies are noted. We are going to start with one item. I've interacted with Mr. Matoons earlier on. He did not, I think, change the item number 2. We are going to request the Home Affairs, the legal team, Advocate BS, Minister will guide us. Colleagues and members, you will recall that we have taken a decision on Wednesday, to stand off the deliberation on the whether we must subject this process to the public hearing or written comments on the 2 issues that were introduced, which are substantive. And we've said that we'll interact with the legal team, parliamentary legal team, just to get more sense in terms of their advice to the committee, because they've been advising the committee or parliamentary work in various committees in terms of the issues that the parliament must engage on. And we did condone that exercise. We've also interacted with tried to request the minister to interact with the law, with the advices of the legal team, Advocate BS and his team, just on the matter that is before the committee, and will then able to deal with this matter once they've also put their opinion. I'm not certain whether, Minister, our request was carried or whether the department is ready. I want us to have this presentation before the item number 3, so that if there are comments from both the state law advisor and the parliamentary legal services, will able to note it, even the IC, if there'll be an interested party. But I know either way, whether we proceed or not, the IC is also going to be affected on our decision. They may not have a position. I'm not speaking on their behalf, but because the decision lies with the committee, but they will give them a opportunity to comment, because this is an important matter of national interest. And I think we must trade with more caution in terms of the process. We're already at the tail end of this process. And I think we've sufficiently considered the process as we've started with the guidance since we've in this matter. So I will request the minister, but if the minister is not consulted enough, you will indicate. If you have done so, you will request just a brief presentation on this matter. Then I'll invite parliamentary legal services to comment. We know that the advice of the parliamentary legal service, what they're still affirmed on their decision to affirm, to assist and to guide the committee on what they've communicated to us. Minister?
Thank you, Chair. Thank you, honorable members of the committee. Yes, Chair, I'll call Advocate Steve Bartlender, as you know, the legal team of the Department of Home Affairs, who were the drafters of the bill, to make a presentation, because after Wednesday, yes, when we did not comment, is because we did not consult the legal team, wanted to hear their views. So I want him to directly present the views to the committee. Thank you. Advocate Bartlender, please, Senior Counsel.
Thank you, Minister, and good morning, Chair. Good morning, honourable members. Honourable Chairperson, I have been asked to set out my views and those of Advocate De Beer, who is assisting me, on two questions. The one is whether the National Assembly should allow for a further brief period of public consultation on the new amendments. And the second is whether an application for extension should be launched to the Constitutional Court in order to achieve this. I'm going to summarize my views, but in essence, the conclusion, let me start with the first issue. As you know, Chair, what has happened in this bill is that the NCOP Select Committee has introduced two material substantive amendments to the bill. The first is the provision about the level of support that is required in respect of political parties in order to run in elections, and related, the level of support that is required for independent candidates. That's the signatures requirement. The second is the provision establishing a consultation panel which will make recommendations on the way forward in respect of elections after 2024. Now, those are issues that were not before the National Assembly last time, and they arose in part from the public participation process and also the issues that arose in the public domain. And so the question is, in light of that, is there a need for the National Assembly to allow further public participation? Chairperson, on the one hand, and we've looked at the relevant cases, we've looked at three cases. The first case is the Electronic Media Network Limited case in the Constitutional Court. There, what the court said is where you're dealing with public participation, there is no need to allow further consultation when the people commenting would have been able to anticipate what the change might be and should have commented at that time. And then we've looked at the Merafong Demarcation Forum, which also held that there was no requirement that public participation require an ongoing dialogue, and that the legislature is not precluded from changing its mind. Now, those two cases might suggest that there isn't a need to engage in further public consultation. But then there's the third case, which is the South African Veterinary Association case. That was the case in which a provision was introduced to deal with veterinarians under the bill, which had not previously been part of the bill. And the concern was that was not subject to public participation. So the cases point in different directions depending on how you read them. But on balance, and we think an argument can be made that there is no need for further public consultation. But on balance, our view is as follows. We think that it would be prudent to engage in further public participation just on these two narrow issues. It can be a shortened period of public participation. There's no difficulty with that, but we do think that there does need to be a period of public participation. There could also just be public participation by means of written submissions. There's no need to have oral hearings of those public participation, but there does need to be some form of public participation, we think, in relation to that. That's the first point we would make. And the second point we would make is it's for the committee to determine whether that can occur before the 10th of December, which is in 8 days' time. But if there is not time to do it before the 10th of December, then our view is that an application for extension must be made, and it must be made urgently. It should be launched at the very latest on Monday. And it should be for a very limited period, perhaps a month or perhaps 2 months, whatever the committee deems appropriate. But our view, therefore, is that there does need to be further public participation. What the extent of the public participation is really for the committee to determine. And we do think that in these circumstances, it would be permissible for the committee to say it's going to be a shortened period. It's only going to be written submissions, not oral submissions. That would all be permissible. But it's for the committee to determine that. And once the committee does, that will dictate whether an extension is necessary. But if the committee is not going to apply for extension, let me be clear, what would need to happen is not just that the bill is passed by the committee, but that it's also signed by the president into law by the relevant deadline, which is the 10th of December. So I hope that summarizes our position for you, Chairperson.
No, thanks very much for that submission. I'm not sure if Minister want to add. Minister?
No, Chair, no.
Okay.
Thanks for
thanks for that submissions. I think members, you will note that. Can I check with the state law advisor before I invite members? Parliamentary Legal Service, let me start with you and bring the state law advisors. Mr. Njigela? Mr. Matonsi?
Yes, Chair.
Oh, I thought it's on my side.
Good morning, Chairperson. Can you hear me?
Yes, proceed.
Chairperson, there are just a couple of things that perhaps we should be saying to the committee at this stage. And I think Advocate Butlander has somehow made our work a little bit easier for today. Chairperson, the committee will recall that there is a deadline that is looming. And he has already mentioned that it's the 10th of December, which is, as he accurately stated, less than 8 days from now. And it seems, Chair, to me, it has become apparent already that there may have to be an application for an extension of that. We can have a discussion as to how much time Parliament will need. We have an idea in our mind that it could possibly be up to February. Chair, having said all of that, there is a question that, again, Advocate Butlander raised, the issue of further public consultation and to what extent perhaps we need to go in doing that. Chairperson, and I'm sure the committee will be aware of this, but in circumstances like this, it is sometimes necessary that we state the obvious. And which is what I'm going to do now. One point that we need to say, Chairperson, to the committee is that indeed, if there is going to be further public participation, the committee must be mindful of the fact that we are already in December. And that ordinarily has an impact on the quality of public participation that you may have in this kind of work. And I think the courts have previously said that it's not reasonable to make these extension over a period where people may be otherwise engaged. So there is that first consideration that it's December. Many people, I'm sure, by mid-December will be going on holidays and doing all our sorts of other things. That fact firstly has an impact on the amount of time that you want to give the members of the public. And again, the second reality, Chairperson, is that when people leave in December for holidays, they normally come back from those mid-January. So this is the first consideration, Chairperson, that if at all there has to be an extension, which we are convinced that in the circumstances, it seems like an application will have to be made for an extension. And of course, we can have a debate, but I'm just setting it out, Chairperson, so that as we speak of an application for extension, we consider the December intervention and the January intervention, and we need to be realistic to each other, because what will be most embarrassing is for Parliament to approach court in December and find itself having to go again and ask for another extension. So we need to be fair to each other and to the members of the public who have an interest in this matter. That is one issue, Chairperson. And of course, Chairperson, the other issues that have been raised are the issues that are already part of the bill. And where it comes to this, if indeed there has to be an extension, the question is, what is the extent of that extension and what determines that period? And in our view, there is one particular issue, is that if there are changes that have been effected, as we know from the other house, those amendments have to be advertised, and we need to be influenced by the materiality of those changes that may have already happened. And that assists in determining the amount of time that you may need. Chairperson, those are the issues. But of course, Chairperson, I'm not flying solo. I'm flying with my colleague, Ms. Kassan. I don't know if there is anything else that she may want to add. But Chairperson, before she does that, there are two things that I've tried to summarize here. The need for the extension to allow for this public consultation to happen. Electoral laws amendment, as you will know, Chairperson, is a very sensitive matter for any political.
Chairperson,
Minister?
may I ask for your indulgence? My deep apologies. Advocate Bartlender is asking if he could leave or if there are any questions. Unfortunately, he had only 15 minutes because he has got other things to do in court. He was asking if he could leave or if members would like to ask him a question before going.
Sorry, Mr. Njikela, for that. Advocate Malekate, I think, will, if the notes have been shared with your team, we can allow the advocate to excuse the meeting. But I think we must appreciate their submission to yourself. Can I get from you whether Advocate Malekate can proceed with the, my understanding is that there was an interaction in between yourselves and the Advocate Bartlender.
Yeah, indeed, Chair. Indeed.
Okay, thank you, Advocate Bartlender.
Thank you very much, Chair, and sincere apologies. It was only at the last minute that I was asked to attend, so I do apologize.
Noted. Thank you very much.
Thank you very much.
We've thank very much. Sorry, Mr. Njikela, I think you can. I think you have concluded, but you can just sum it up.
Chair, thank you very much. I was just concluding, Chairperson, and saying there are two things which I think are very important for the committee to consider at this stage. Given what Advocate Bartlender has said, that we have basically 8 days to the deadline. Whether there should be an application for extension and how much that application should be. And perhaps thirdly, to what extent we may need to have further advertisements of those areas that we consider to be material for the purposes of public participation. Those are the three issues, Chairperson, that I feel maybe I should put to you before Advocate Bartlender may depart. so that I have worked with Advocate Batlender. If there are any legal issues, I'm sure we can be able to engage outside this process. But I thought these were important that they are deliberated on in the meetings of the committee. Chairperson, with your permission, perhaps my colleague would like to add something that I may have left out. Daksha.
Good morning, Chairperson. Good morning, honourable members. Mr. Chikela has fairly covered everything that our office has talked about, except to say that we want to reiterate that we need to take our guidance from the Sava judgment, and this committee needs to be guided by the fact that any material changes made to a bill that have not been in the public domain needs to be further consulted upon. And we would therefore agree with Advocate Batlender's conclusion that the proposals made from the Select Committee, if considered to be of a material nature, needs to be advertised, and there should therefore be a call for further comment. Thank you.
Thank you very much. Is there any other comment? Okay. State Law Advisor.
Thank you, Chairperson. Chairperson, we listened carefully to the views expressed by the department as well as Parliament, and we are in agreement with the views expressed by the department in respect of the applicable case law with regard to public consultation. Chairperson, we have nothing further to add. Thank you.
Thanks very much, members. Those are the submissions that were made by both the legal team. I'm also going to welcome Honorable Melda in our meeting. We'll give you an opportunity if you want to interact with that. We're going to now invite yes, Mr. Siviwe, can you mute? Yes, thank you very much.
Apologies.
No problem. We're going to invite members to comment on the process. Now that we've brought the legal team, we've consulted with them, and then we'll invite the state law advisor to present the C list. And I must also apologize that we started the meeting at 10 instead of 9 on the reasons that were communicated by ourselves and Mr. Matonzi to the meeting. And thanks, members, for noting that. We'll start with Honorable Mudise, Honorable Zell, Honorable Molekwa, Honorable Kanyile, Honorable Tito, Honorable Ramolobeng, Honorable Mohale, Honorable Melda, Honorable Rose, and Honorable Pile. In that order.
Thank you very much, Chair. Let me also thank the presenters on the issues that they've presented to us this morning. We truly do appreciate the counsel and the legal advice that we got from all the members who are here in the meeting and who have given us that guidance. Chair, we would have paused on the meeting, the portfolio committee meeting on Wednesday on this item, solemnly to seek proper counsel and guidance from the legal minds that we have. And indeed, we have truly received that. And I want to move and suggest that we take counsel as it has been received and follow proper processes of Parliament and seek an extension as members have suggested, and indeed take the amendment bill back to the public for comments, I want to suggest that we may not need to take it for oral comments, because we know that process will take time, and also resources and logistics wise will really require a lot of those. Therefore, we may need to take it for written submissions, which at most it's 14 days minimum. We also do take a note of the fact that it is a festive season. We may not be able to submit or advertise for public comments on the bill during the festive season. Therefore, we may then need to look at the most convenient time, which will be in January, for us to be able to process this bill. We take counsel on this, members, because we honestly do not want to find ourselves on the wrong side of legal processes of Parliament. Also taking into considerations that we also do have a responsibility to the members of the public who have shown an extensive interest during the processes of us dealing with this bill the past few months. The large interest from the public, including civil society organizations and general members of the society, because the electoral amendment really does speak to the heart of our people, and there was an interest. Therefore, it's important that we really do not falter.
Honorable Mudisemza, can you come closer to the mic? I mean,
to have an opinion or to voice their views on these amendments that have been made. Therefore, Chair, I fully support, and I want to move that the committee should move for an extension, to seek an extension at the courts, and also to take this amendment bill for public comments. Thank you very much.
Thank you for your contribution, Honorable Mudisemza. Honorable Lizel.
Good morning, Chairperson. Good morning to you. Good morning to our Minister. Good morning to our DG, colleagues, the leadership of the IEC, and our legal advisors that have been so ably assisting us on this journey. I really welcome the legal opinion that was provided to us this morning. I do fully agree that the changes are of a substantial nature, and therefore we do need to further consult the public on these clauses and the substantial material changes. I think it's very clear that we will not make the court deadline of the 10th of December, considering these new changes that have been sent to us from the NCOP. And so I would agree then that we, on an urgent basis, Chairperson, approach the court. As Mr. Butlander had said, we should do so by no later than Monday. I also fully agree that we should keep the period of extension short. In fact, it is my view that we could always, as soon as the court grants us, if they do grant us the extension, that we immediately start advertising and asking the public for written submissions. I think then, because people will have the opportunity then throughout the December period, I know we do have concerns in terms of the fact that people are on holiday, but we do extend that written submission period into January. And then we can also, as an added extra, if we do see that there has been a lot of written submissions, we could possibly, if some of these people who have given us written submissions, if they do ask for oral submissions, that we could maybe towards the end of January have 1 or 2 days virtually. Doesn't have to be in person. We can do virtual public hearings, oral, if there are a requirement for that towards the end of January, and that we then speedily finalize the bill in the beginning of February to be passed by the National Assembly just after the opening of Parliament, which will be mid-Feb. So I think if we do ask the court to give us or grant us this extension till the end of February, it will allow us to do justice to the process. I think it's important that we do consult further, and it will allow us to do so. And also because the period that we are covering is January, December, January, and February, I don't think it will have devastating effects in terms of the IEC's planning, because I also assume that they would want to enjoy Christmas with their families. So at least then, this allows us to do justice to the process. It will take us up until maybe end of Feb, but I think that is the right approach. And so I fully support the proposals that have been given to us. Thank you so much, Chairperson.
Thank you very much for your contributions, Honorable Lizelle. Honorable Molekwa.
Thank you very much, Chairperson. Let me also start by noting the issues raised by the legal department. And also I would like to concur with Honorable Modise and Honorable van der Merwe on the issue of the extension. But Chairperson, before we agree on the issue of the extension, I just want to check if the issue of the extension will have legal implication. Maybe we can be advised on that, Chairperson. Thank you very much.
Thank you very much, Honorable Molekwa. Honorable Kanyile. Okay, maybe there's a network problem. Honorable Tito. Okay, Honorable Ramolobe.
Chairperson, may I come in, please?
Yes, you can come in. I thought you were challenges, but proceed, Honorable Kanyile.
Thank you very much, Chairperson. Greetings to you. Greetings to the colleagues and the legal team that is with us in this meeting. I am also in support or concur with the previous colleagues that have spoken before me that we need to approach the court and request for an extension to allow for public participation. I think as a committee, we also need to agree on a time frame that will be needed to advertise or to allow the participation so that we can be able to know exactly when will be the extension that we need to request. I think I have been covered in that aspect largely by Honorable Lizelle when she suggested mid or end of February. Thank you very much, Chairperson.
Thank you, Honorable Kanyile. Honorable Ramolobe, if you are, can I come back to you?
Thanks, Chair. Good morning to colleagues, the legal team that we have, the department as well. Chair, let me welcome the presentation made by the legal team that we have amongst us on the extensive report they've given or advices that they're advising the committee on. And Chair, through that wisdom, I would want to concur with Honorable Modise and the legal team as well in saying we do need to seek for an extension to the Constitutional Court regarding the Amendment Electoral Bill. And therefore, we require to do this as early as on Monday. But I would want to also pose the same question as Honorable Molekwa. What are implications of those extensions if we have from the legal team that we have? Two is that, Chair, I also concur with the previous colleagues on the issue of allowing for an extension, not necessarily an extension, but to take the amendments that have been made towards the bill for public participation, Chair. Thank you.
Thank you very much for your contributions. Honorable Mohale. Okay, Honorable Melda.
Thank you for recognizing me, Honorable Chair, and for allowing me to speak. No, I think that we're fairly on the same page today. The Advocate Badlander actually said it quite clearly that it's a responsible thing to do.
Honorable Melda?
Yes, Honorable Chair.
Yes, I'm not sure whether you I'm trying to protect you. Just to, I'm not sure how to put it, but I thought,
just tell her to mute the video. So
I
that we
muted
only hear
Keep the video off.
I muted.
Yes.
Could you hear me quite clearly now?
yeah, now hear it quite clearly, so that we can hear it quite clearly. Yes, let me put it like that.
Thank you, Honorable Chair. Thank you for recognizing me and allowing me in the meeting. Now I'll be short. I just wanted to appreciate the presentation by Advocate Badlander. And I also think that we're fairly on the same page, that we should approach the court on Monday as soon as possible. But I think it's very important that the committee decides on what exactly is going to be asked from the court. And that should be well thought through, because if we appear in the court or approach the court and we ask them for something that's not reasonable, then we would actually have further consequences. So let's do that. It's unfortunate that we're sitting with a situation at this time of the year, but it is what it is. So I think it's a responsible thing to do. Thank you, Chair.
Thank you very much, Honorable Melda. Honorable Ruas.
Thank you, Chairperson. I'll leave my video off as well for the sake of everybody's bandwidth. Chairperson, yes. First of all, to appreciate the presentations that were given. It certainly added weight to the argument that we should take public participation and that we should request the extension. I certainly support what Honourable Modise proposed as amended by Honourable Lazelle. I think if you look at the timeframes that we have, and I've kept a track of the spreadsheet that the IEC gave us right in the beginning of the whole process, we have about 241 days spare. If you look at that schedule and the absolute limit of how long we can take to still do this. So I believe 3 months is a reasonable extension to ask right about the end of February. That should allow us to complete this process. Thank you, Chair.
Thank you very much, Honorable Ross. Honorable Pile.
Good morning, Chairperson, Minister, and all colleagues on the platform, other honorable members. Chair, thank you. I think first we must appreciate the counsel that we have received. And we must say that at all times we have endeavored as members of this committee to ensure that while we take into cognizance the Constitutional Court ruling and be able to look at the changes of the Electoral Amendment Bill, that whatever we do is within the prescripts of the law, and that at all times we put the citizens of our country first. And I think that all South Africans are waiting patiently for us to finalize this bill. And if anything, we don't want to leave any loopholes, and we want to be able to finalize the process, but also do it in the right way. And in light of that, Chair, I think it's absolutely necessary that as a committee, we allow for public participation through written submissions. And so I support Honourable Modise and Honourable Lazelle that we should open for public comments, that we do approach the courts for an extension, and that the committee gives authorization for that to happen immediately. If papers can be filed today, why not? If not, then Monday, and it should happen. And in doing so, I think it's also important to alert the courts that Parliament is in recess as of next week, and that hence even the call for submissions will mean that we'll have to be able to table this report for finalization when Parliament opens. So it's important to make mention that we are going to allow for that participation. But I think we must be also fair that the NCOP has deliberated, in the short space of time that they had, and they were able to bring it to us. Unfortunately, due to the substantial amendments, we have to go back to public consultation. And I think, Chair, that we must commend all members for the tireless work that they've put into this, all stakeholders, And I fully support the proposal that we, one, request an extension by the court, and two, we call for public comments and submissions. Thank you, Chair.
Thank you very much, colleagues. Members, there was a matter I think was referred to the IEC in terms of their, if I got it correctly, the timetable. What does it mean in terms of the process to be engaged by the IEC? Can I invite Commissioner Meabza just to comment if there's any comment? Commissioner Meabza?
Thank you, Chairperson. I'll also just leave the video out. I have noted, and I'm sure the members of the Commission are online. They're also noting the submissions made. Chairperson, I think for us there are a number of important things, I imagine, and we will have to retreat and look at them. I have indicated on Wednesday when we met that we had looked at the technical information that we had used to underpin the work we need to do once the bill is passed. And we had indicated upfront that up to the 10th of December, there should not be a problem. We will have to look at this. There is a reality we have to face. The bill will not be ready on the 10th, as we have heard. What that would mean for us is something different, because it does mean that our preparations will not be what we thought they would be. Having said so, we understand that the council team is looking at the papers being served as soon as possible. I think the best way we can engage with it is based on the papers before us. A number of things are important. One is council talks about a time as short as possible. We hear members talk about 2 months, 3 months, and I think there is a danger in an extended period, at least on our part. And one would see that from the papers we gave to the committee as well as to the court. Accepting that there is a reality, I think the time period must indeed be as short as possible. I assume it would be. The second thing, Chair, I wanted to just raise, and I did not raise because I thought that two things were going to happen in parallel. It appears that they may or may not happen in parallel, and these are: does the committee wait for the application to be launched to invite? Does it wait for the court, or does it do that upfront? That is also very material, because it's going to determine how soon comments can be considered, received and considered. But these are matters I leave to yourselves in the committee. We will consider the matter, and we will have to look at the proposal that is made on the papers to the courts. I guess I represent the position of the Commission fairly. Thank you so much, Chairperson.
Thanks very much, Commissioner Meabza, and I'm also noting that that is the comment of the IEC. I'm getting it correct, Commissioner Meabza?
Chairperson, I do indicate that I represent the Commission, but we will have to, once we get the papers, we'll have to look at the best ways we deal with the matter. I think to just say 3 months is good, 2 months is not good. In our submissions to yourselves and to the court, I think we have extensively laid down where our our challenges would be, and those realities we now confront, and we have to find ways to deal with them, and we will respond to them in the best way we possibly can.
Okay. No, thanks, members. Thanks, Commissioner Meapza, with your team. The committee take a decision that we must approach the Constitutional Court on two substantive issues that have arisen from the NSOP, and the committee has now considered adopted, and that will seek consultation with our people. So that's the first point that we've taken a decision on, and we've considered that. The second point, which I think we have taken, that we must then approach the Parliament to request permission for that decision that we have carried. Thirdly, is that we must caution, and I think it's a caution that the IEC has now resubmitted to the attention of the committee on the period that we must deal with this public consultation. We are going to carry for written submission for a shortest time, because at least both the houses have deliberated on these issues. We've benefited from the comments on the issues, and we can able to, because there are only two specific matters that we need to call for written submission. And I think we must consider that we may need to do a shortest time period to conclude this matter. In the constituency period, we may and will further seek guidance as to whether Parliament will not able to convene to pass this amendment, this bill, so that time is also allowed for President of the Republic to look and consider what Parliament will have referred to his attention. So that is how we're going to deal with this matter, Mr. Njigela. I must re-emphasize that we'll need a shortest time to deal with this amendment, public written submission. If we're granted earlier that we must proceed by the Constitutional Court, I've already interacted with the staff that we must gear up for written for advert, so that we're able to finalize on this matter. The only area where I want to also get an understanding from legal and the state law advisor, if we're not granted the extension, and I think it's a matter that has not been raised in the meeting, what then is a recourse? I'll give that Mr. Njikela to come in. I see the hand of Honorable Rose and Mr. Salmon. Then I'll come back to you so that we're able to close on this item, and then we'll move to the list reading. Honorable Rose.
Thank you, Chairperson. Chair, I just noted that you'd mentioned that the public participation should only be on the two items that were raised as being material. And Chairperson, I'd just like to propose that we rather just call for the public participation on all of the NCOP amendments, because I think it's one interpretation to say that those are the only two material amendments. But you could argue, for example, that there was an amendment about using the filling of the vacancy instead of using the other method, and that's, some would argue that has a material change to the whole thing, because it changes the PR allocation versus that allocation. So, Chair, I would propose to either add that as a material or to be safe, because we are now going through this process that is time consuming, to rather just make all the changes proposed by the NCOP open to public participation. Thank you, Chair.
Noted, Honorable Ross. Mr. Salmo.
Thank you, Chairperson. Just to indicate that we have, in fact, prepared an advert to call for public comments, and that we will need to wait until we get the approval from the Constitutional Court prior to sending that advert. And we will adjust the timeline for the submission of those submissions based on how soon the court gets back to us. So at this stage, we're imagining by the end of January to allow for the 2 weeks, last 2 weeks of January for public submissions to be made when everybody is back from their festive season preparations. And then we will probably need 2 weeks then to look at the submissions and for the processes in the NA to complete. And then bearing in mind that the presidency will also need at least a month, I'd say, from then to consider the deliberations. So we could potentially meet around the first or second week of February to start processing this, even if the parliament hasn't opened yet, just to expedite the process a little bit. But yeah, we have this advert ready, and it includes all the NCOP submissions. So the public will be able to make comments on all of those as requested by Honorable Ruiz. And that's just from my side. Thank you, Chairperson.
Thank you, noted. Thank you very much, Mr. Salmo. Mr. Njigela. Daksha.
Chairperson, from what has been already said now, there are just two issues that perhaps one should raise with the committee. And these directly emanate from what the members have just said now. The first issue, Chairperson, is the issue that relates to the issue of amendments proposed by the NCOP or any other amendment for that matter. Whether the scope of the advertisement should be limited to that. I suspect, and my colleagues can come in, that perhaps if we do seek the extension, that the level of engagement should be broader than just what may have been proposed by the NCOP. And this is predicated on an assumption that we are granted the extension, rather than limit it to specific issues, rather have it open. But of course, that chairperson should not necessarily have an impact on the time frame of the extension that we seek from the Constitutional Court. The second issue, Chairperson, that has, as I think it was Honorable Roos raised, was what if the court does not grant the extension? Chairperson, it's a difficult question to answer, because whether you are granted the extension or not depends on the case that you're making. And I will here express a preliminary view. And I think the courts have said this a number of times, that any democracy is, the quality of any democracy is influenced by the extent of public participation. And I think the Constitutional Court has said that a number of times, and I don't think it will be different here. But if it comes to that, Chairperson, that at all you are not granted the extension you are seeking, I suspect that the court will issue specific directions to Parliament in terms of how it deals with the issue of this legislation, and possibly how it deals with the issue of management of elections. I can't foresee a situation where it will simply refuse without providing some directions as to how Parliament and the IEC should be dealing with the matter going forward. But in my view, that is the worst case scenario, which I don't think we are there yet. Chairperson, I think those are the issues, unless my colleagues, Daksha wants to add any other issue to that. But those will be my view for now, Chairperson, based on what has already been said.
Chairperson? Chair, this is Daksha. Can I just add my viewpoint?
Yes, proceed.
Hi, I just want to clarify what Mr. Chikela might have meant to say, but said it incorrectly. I don't think he meant to say that the entire bill must be open for public comment. What he intended to say that, and this is in light of what Mr. Roos said, is that we shouldn't limit the public participation to only the two issues raised by Advocate Butler this morning. We should extend the public participation to all the proposed amendments made by the Select Committee, because as Mr. Roos has said, the amendments that are proposed to Schedule 1, which is Clause 21, could be considered to be of a material nature, because the nature of the calculations are now changing. The most votes that an independent candidate got is now changing to highest proportion of votes. So I would propose that instead of only commenting or advertising the two changes that were alluded to by Advocate Butler this morning, that all the proposed changes made by the Select Committee be advertised, but not the entire bill. Thank you, Chair.
Noted. Mr. Salmon?
Yes, Chair. I just wanted to confirm that point because, yeah, if we have to re-advertise the entire bill, it will definitely affect the impact on how the submissions are dealt with. There's going to be a lot more submissions, a lot more content, and a lot more time needed to analyze and present and consider. So, yes, I'd just like to confirm what Daksha just raised. Thank you.
Okay. No, thanks. Carried that will advertise proposed amendments from the NCOP. We're now standing off this item. I'm inviting Ms. Govender to present the C list.
Good morning, Chairperson. Good morning to the Honourable Minister, members of the committee and all others present on the platform this morning. Chairperson, may I just ask, would the committee prefer that we just highlight those matters that arose at the last meeting, or would the committee prefer that we go through the entire proposed list of amendments?
I will, members will guide if they will be in contrary. I will advise that we go through all the proposed amendments. Then members will comment from that. Is this carried, members? Yeah, I'm sure they agree now.
Chair.
Okay.
Yes, Chair.
Ms. Govender, thank you.
Thank you, Chairperson. I will be switching off my camera for bandwidth reasons. Thank you, Chair.
Thank you.
Chairperson, the C list that was circulated, I think it was early this morning. We will be going through that. It's the Portfolio Committee amendments to the Electoral.
Sorry, Ms. Govender, can you share it on the screen?
Chairperson, would the committee secretary be able to share it? I think Eddie does have it. He actually circulated this morning. Can I just check with him if he is able to share it, Chairperson?
I know he had an email problem, but can you check, Mr. Matonsi, can share it?
No, I have it, but I've shared it. Nobody can nobody see it? I don't know why it's not showing.
I'm saying the platform will require that at least even those interested outside this meeting may benefit to the proceeding of the meeting. Mr. Salmon, can you share it?
Are you able to see it now, Chairperson?
No, we can see your items of.
Yeah, because it shows that no participant can see you.
I will try share. Yes, Chairperson.
Yeah, I can intervene.
I see. Just bear with me for 1 second, Chairperson. I'm just busy opening the relevant document.
Yeah, Ms. Govender, you can proceed in the meantime when we're still dealing with the share. Thank you.
Thank you, Chairperson. If we can go to page 2 of the proposed amendments. In respect of clause 3, on page 3, in line 24, after following, to omit paragraph and to insert paragraphs. Point 2, on page 3, in line 28, to omit the closed inverted commas and full stop. On page 3, after line 28, to insert the following paragraph. CB, form, in the case of a registered party not represented in the National Assembly or any provincial legislature, confirming that the party has submitted in the prescribed manner the names, identity numbers, and signatures of voters whose names appear. 1. In the case of an election of the National Assembly in respect of regional seats on the national segment of the voters' roll and who support the party. AA, totaling 20% of the quota for that region in the preceding election when nominating candidates for one region, or BB, totaling 20% of the highest of the regional quotas in the preceding election when nominating candidates for more than one region, provided that where 20% of the highest of the quotas is not achieved, that the party may only nominate candidates for the region or regions as determined by the next highest quota. Or 2, in the case of an election of a provincial legislature on the segment of the voters' roll for the province and who support the party, totaling at least 20% of the quota of that province in the preceding election for which the party intends to nominate candidates. Chairperson, we now go on to clause 6. On page 4 of the bill, to omit lines 21 to 28 and to substitute with the following paragraph A. A completed prescribed form confirming that the independent candidate has submitted in the prescribed manner the names, identity numbers, and signatures of voters whose names appear. 1. In the case of the election of the National Assembly in respect of regional seats on the national segment of the voters' roll and who support his or her candidature, AA, totaling 20% of the quota for that region in the preceding election, if intending to contest only one region, or BB, totaling 20% of the highest of the regional quotas in the preceding election, if intending to contest more than one region, provided that where 20% of the highest of the quotas is not achieved, that the independent candidate may only contest the region or regions as determined by the next highest quota. Or 2, in the case of an election of a provincial legislature on the segment of the voters' roll for the province and who support his or her candidature totaling at least 20% of the quota of that province in the preceding election, which the independent candidate intends to contest, provided that an independent candidate who was elected to either the National Assembly or a provincial legislature as an independent candidate in the preceding election shall be exempt from this requirement. Moving on to clause 21. On page 11, in line 43, to omit most and substitute with highest proportion of. On page 12, in line 24, after seats to omit provisionally. On page 12, in line 25, to omit item 5H and substitute with item 5I. Chairperson, the committee will recall that number 2 and number 3 under clause 21 were the two proposed amendments that came up at the last meeting and was agreed to by the committee after having been explained by the IEC as to why that was required. Moving on to item 4, on page 12, from line 48, to omit most number and substitute with highest proportion. On page 12, to omit the sentence in lines 59 and 60. On page 13, from line 5, to omit minus the votes cast in such region in favor of independent candidates already allocated 1 seat. On page 13, from line 9, to omit minus the seats held by independent candidates in terms of item 5E. On page 15, from line 16, to omit independent candidates already allocated a seat must further be disregarded in such recalculation. On page 15, from line 22, to omit minus the votes cast in such province in favor of independent candidates already allocated 1 seat. On page 15, from line 26, to omit minus the seats held by independent candidates in terms of item 11D. On page 17, from line 23, to omit the forfeiture provisions in item 7 or item 12 as indicated by the context and substitute with item 23. On page 17, from line 29, to omit calculations performed in terms of the forfeiture provisions in item 7 or item 12 as indicated by the context and substitute with recalculations performed in terms of item 23. On page 18, in line 4, to omit party or. On page 18, in line 9, to omit in terms of item 5I or item 11F. On page 18, in line 34, to omit item 7 or item 12 and to substitute with item 24. On page 18, from line 36 to line 39, to omit paragraph G. On page 18, in line 49, to omit item 7 or item 12 and to substitute with sub-item 3. On page 18, after line 49, to insert the following sub-item. 3A, an amended quota of votes per seat must be determined in respect of such region or province by dividing the total number of votes cast in the region or province minus the number of votes cast in the region or province in favor of the party or independent candidate standing to lose a seat, minus the votes cast in such region or province in favor of independent candidates already allocated 1 seat by the number of seats plus 1 determined in terms of item 4 or item 8 in respect of the region or province concerned, minus the seat or seats retained by the party or independent candidate, minus the seats held by the independent candidate. B, the result plus 1, disregarding fractions, is the amended quota of votes per seat in respect of such region or province for purposes of the said recalculation. C, the number of seats to be awarded for the purposes of paragraph F in respect of such region or province to a party or independent candidate participating in the recalculation must, subject to paragraph D, be determined by dividing the total number of votes cast in favor of such party or independent candidate in such region or province by the amended quota of votes per seat indicated by paragraph B for such region or province. D, where the result of the calculation referred to in paragraph C yields seats not absorbed by the number awarded to parties or independent candidates, the surplus of votes accruing to any party, parties, or independent candidates participating in the recalculation competes for the remaining seats in sequence of the highest surplus of votes. E, the aggregate of such a party's award in terms of paragraph C and D in respect of such region or province, subject to paragraph F, indicates that parties or independent candidates' final allocation of the seats determined under item 4 or item 8 in respect of that region or province. F, in the event of a party being allocated an additional number of seats in terms of this item, and if its list in question then does not contain the names of a sufficient number of candidates as set out in item 7.1 or item 12.1, the process provided for in this sub-item must be repeated with the changes required by the context until all seats have been allocated. The new clause, which will be inserted on page 19 after line 12, to insert the following new clause after clause 22 and to renumber the existing clause 23 as clause 24. Electoral Reform Consultation Panel. Section 23, 1. Within 4 months after the commencement of this section, the minister must establish the Electoral Reform Consultation Panel. The functions of the panel are to independently investigate, consult on, report on, and make recommendations in respect of potential reforms of the electoral system for the election of the National Assembly and the election of the provincial legislature in respect of the elections to be held after the 2024 elections. Chairpersons, the committee will recall that at the previous meeting, it was agreed that the wording non-binding would be removed from 2A. That has been given effect to in this list of amendments. Moving on, B, the panel must perform its function referred to in paragraph A in a manner that enables Parliament to exercise its constitutional powers to determine the electoral system for the elections of the National Assembly and provincial legislatures in respect of the election to be held after the 2024 elections. 3, the panel must, A, prior to the 2024 elections, engage in research and consider the issues falling within its functions. B, after the 2024 elections, undertake a public participation process regarding the issues falling within its functions. And C, from the date of its establishment, submit a report to the minister every 3 months on its progress. 4, the panel must, within 12 months of the date of the 2024 elections, submit a report to the minister on the possible options for electoral reform for the election of the National Assembly and the election of the provincial legislatures, which must include A, reasons, potential advantages and disadvantages, B, legal and constitutional implications, and C, financial implications for each proposed electoral system or electoral reform identified by the panel. 5, A, the report contemplated in subsection 4 must reflect the views of the members of the panel as to the possible options and recommendations for electoral reform. B, in the case of disagreement as to the possible options and recommendations for electoral reform, the report may be divided into different sections, setting out the different views of the members. 6A, in the event that the panel is unable to submit the report contemplated in subsection 4, the panel must, no less than 3 months before the date on which the report is due, make a written request to the minister to allow the panel an extension of no longer than 6 months to submit the report. B, the minister may, upon receiving the request referred to in paragraph A, grant the extension on good cause shown, provided that such an extension may only be granted once. 7, Upon receipt of the report contemplated in subsection 4, the Minister must, within 30 days, table the report in Parliament for its consideration and publish the report through electronic and any other means. 8. The panel is authorized to do all things necessary or incidental to fulfill its functions, including A, to call for and receive written submissions from political parties, independent candidates, civil society organizations, and any interested person or party in respect of potential reforms of the electoral system, and B, to make the written submissions publicly available and accessible through electronic and any other means. 9. In order to establish and constitute the panel, the Minister must A, call on the public and any interested parties to nominate fit and proper South African citizens who, 1, have the necessary skills, expertise, experience, knowledge, or academic qualifications in the administration and running of elections or constitutional law or electoral systems. 2, are not members of Parliament or of any provincial legislature, and have not in the past 12 months been office bearers or employees of any political party. B, in consultation with the Commission, appoint 9 members to the panel from such nominated persons who satisfy the criteria specified in paragraph A, and C, appoint one of the members of the panel as the chairperson of the panel. 10, a member may resign from the panel by giving the Minister A, 1 month's written notice, or B, less than 1 month's written notice with the approval of the Minister. 11, the Minister may, after taking the steps required by subsection 12, remove a member of the panel if that member A, committed an act of misconduct, becomes incapacitated or is incompetent, B, is unable to perform his or her functions for more than 30 consecutive days, C, acted contrary to the fulfillment of the panel's functions, or D, neglected to perform the functions as required by a resolution of the panel. 12, before removing a member of the panel in terms of subsection 11, the Minister must afford the member an opportunity to make written representations and must consider those representations. 13, A, should a vacancy arise in the panel, the Minister, in consultation with the Commission, must fill the vacancy from the persons already nominated in the process contemplated in subsection 9A. B, in the event that no suitable person can be appointed, the Minister must undertake a new nomination process as provided for in subsection 9A. 14, a member of the panel who is not in the full-time employment of the state must A, be appointed on such terms and conditions as the Minister may determine, and B, receive such remuneration and allowances out of the funds appropriated for the functioning of the panel as the Minister may determine in consultation with the Minister of Finance. 15, the Director General of Home Affairs must, subject to the laws governing the public service, A, appoint, second, or designate persons in its employ, and B, make available any other necessary resources to assist the panel to enable it to perform and fulfill its functions. 16, the Minister must dissolve the panel. A, after the Minister has tabled the report referred to in subsection 4 in Parliament, and B, once the Minister and Parliament no longer require the panel to perform any of its functions. 17, this is definitions. In this section, A, 2024 elections means the elections of the National Assembly and the provincial legislatures due to be held during 2024. B, Minister means the cabinet member responsible for home affairs. And C, panel means the electoral reform consultation panel established in terms of subsection 1. Chairperson, as a result of the inclusions in the bill, the long title has also been amended, and I will now read that into the record. On page 2, to omit the long title and to substitute the following long title. To amend the Electoral Act 1998 so as to delete a definition and insert certain definitions consequential to the expansion of this act to include independent candidates as contestants to elections in the National Assembly and provincial legislatures, to provide that registered parties must submit a declaration confirming that all of its candidates are registered to vote in the province where an election will take place, to provide that the submission of list of candidates of a registered party not represented in the National Assembly or any provincial legislature must be accompanied by a prescribed form with certain specified details to provide for the nomination of independent candidates to contest elections in the National Assembly and provincial legislatures, to provide for the requirements which must be met by persons who wish to be nominated as independent candidates, to provide for the inspection of copies of lists of independent candidates and accompanying documents, to provide for objections to independent candidates, to provide for the inclusion of a list of independent candidates entitled to contest elections, to provide for the appointment of agents by independent candidates, to provide that independent candidates are bound by the Electoral Code of Conduct, to provide for the return of a deposit to independent candidates in certain circumstances, to amend Schedule 1, to substitute Schedule 1A, to provide for the minister to establish the Electoral Reform Consultation Panel, and to provide for matters connected therewith. Chairperson, those were the extent of the amendments which have been read into the record. Thank you, Chair.
Thank you very much, Ms. Govender, for reading the amendments to the record. Members, is there any other matter to raise on the C list? Can I start with Honorable Ruas?
Thank you, Chair. I'm just trying to follow it here on the document. Just a question on clause 21.9. It talks about province.
Can you, sorry, can you share it again, Ms. Govender?
Chairperson, I think Mr. Adam Salmon had shared it.
Sorry, Mr. Adam Salmon? Let's go to that. Where are you?
Sorry, which section?
So that would be page 3, I think, and then it's clause 21, and then the 9th item. So it's around about the middle there. So it says, minus the votes cast in such province in favor of independent candidates already allocated 1 seat. But then later in the document, for example, in 21.18, it talks about region or province. So should the province in that 21.9 not be region or province?
Okay. Thank you, Honorable Ross. Ms. Governor.
Chairperson, subject to saying that on page 9, on page 3, the wording is actually being omitted, so it's actually being taken out from the bill. I think the IEC would be in a better place to explain the reasoning for the wording of province and then region. Through you, Chair, if they may be allowed to address this issue.
Can I, before that, can I check if there's any other member who want to comment?
Chair, I want to ask a question.
Okay, let me just run with the. Yeah, proceed, Honorable Lizelle.
Chairperson, I'm sorry, but I want to ask just a question of clarity. I'm looking at the new clause of the in terms of the establishment of this electoral reform commission, or the consultation panel. Now, the reading from that, and it's really just, I'm probably just being, I'm playing devil's advocate here, but it looks like the minister is solely responsible for appointing or relieving members of that panel of their responsibilities. And I was thinking, should the appointment of members to this panel not be in consultation with Parliament? Or should it be the sole prerogative of the minister to decide who serves on that panel? I'm just asking because I remember recently in one of the bills that we dealt with at Social Development, it was also the sole responsibility of the Minister of Social Development to appoint members to a SASSA oversight body. And we decided that it should be in consultation with Parliament. So maybe once the minister recommends people to serve on that panel, Parliament should also be given an opportunity, or this portfolio committee, to make inputs to that. I don't know if, I'm just wondering whether it should be the sole, not that I don't trust the minister, I'm just asking whether there shouldn't be a more consultative process in terms of attending or appointing people to the panel.
Okay, noted. I'm going to invite the minister and then invite IEC to comment on those two issues. Minister? DG, do you have a minister on the platform?
Chairperson, yes, we do have the minister. Probably might be having connection issues.
Let me invite the IEC, then we'll come back to the minister. Commissioner Miyabza, you'll guide the comments line.
Thank you, Chairperson. I will, without any waste of time, ask Melanie to deal with the question raised by Honorable Ruas. Melanie?
Good morning, honorable members and colleagues. Mr. Ruas, Ms. Govender was quite correct that the first portion that you mentioned is in fact being omitted now from item 7 and in fact similarly from item 12, which deals with forfeiture. And the reason for combining the regions and provinces in the vacancy calculation is basically just for expedience, so that we don't have to duplicate the exact same wording for a region or a province, because it will actually work in pretty much the same way. I trust that answers. Otherwise, I'm happy to elaborate further. Thank you very much, Chairperson.
Thank you, Mr. Commissioner Miyabza, Chairperson.
Thank you, Chair. Oh, I just wanted to say thank you. That's really the explanation from us.
Thank you. Minister, can you come in? Are you stable now?
Yes, Chairperson. Can you just explain what is wanted of me? I'm sorry about that.
Okay. Honorable Lizel, can you come back?
I think I was simply asking whether once we deal with this new section of the panel that should be guiding the minister on electoral reform, I was asking a question, but probably not from the minister. I was probably asking colleagues whether in terms of, it is the sole responsibility from my reading, it's the sole responsibility of the minister to appoint people to this panel or to remove them. So I was suggesting that maybe the appointment of people to the panel, after the minister has done his work, it should be with consultation or in consultation with Parliament or this portfolio committee. In other words, once the minister has shortlisted or decided on the people that should be appointed, I think Parliament or this committee should also have a say in terms of who should be serving on that panel. And I'm making that suggestion because recently also in the amendment of a bill which dealt with SASSA matters, a board was appointed, and it was at that point the sole prerogative of the minister, but we changed it to say that it should be in consultation with the portfolio committee. So I wanted to know whether that could be a proposal that all of us could possibly entertain. Thank you, Chair.
Okay, I will want to make it easier for your comment. The minister may come later. I think we're raising an important matter on the consultation, either with Parliament or with the portfolio committee, which is an area we may need to note it for now and allow the process of the public comments to run. But in our mind, carry it at the point we're going to deliberate once the public hearings have been, public written submission have been submitted before our attention. I'm getting where Honorable Zell is, and probably I think that we may need to note that part because it's not necessarily asking the minister to respond on the matter, but minister, you can just we get your attitude or your reasoning along this proposed amendment. But I'm fully resolute that this matter we may deliberate on it once we've closed the public written submission. I think it can also be clear like that. Minister?
Yeah, Chairperson, I won't be averse to you deliberating on it. But if you read it carefully, it was very carefully worded such that the minister would not just willy-nilly choose anybody. Remember, they've actually outlined the type of people who must be chosen, their qualifications and their attributes. And it says somewhere, it's just that I don't know in which subsection, that the minister must also consult the what you call the commission. Yeah, the commission. But be that as it may, I think let's give the committee time to deliberate on the matter and look at all the areas that I mentioned here to see if it's really necessary 13. To do so. Yeah.
13.
Is it 13?
Yes, Chairperson. It's 13 on page, what is this? Page 6. It says, should a vacancy arise, the minister in consultation with the commission must fill the vacancy. And I think somewhere above that, they talk about when he's actually doing the appointments as well.
Yeah, but 13 is about the vacancy. Honorable Van der Merwe is about the initial appointment of the committee. I think let's just take the chairperson's advice so that they'll look deeper into it. But I'm definitely not against the committee looking into the matter. Thank you.
Okay, thanks very much. Is there a hand?
Yes, Chairperson, sorry, just to, that the minister was actually referring to, it's 9B, talks about in consultation with the commission, appoint 9 members to the panel. That's on page 5.
Okay, noted, members. Let's note the 2 views that are being carried and allow that process that we have now established so that also get a sense of what the public will be saying around this matter. We'll then note the C list and adopt it after we have considered the public submission from our people and stakeholders, political parties, and civil society in terms of this process. Mr. Njigela, I'm not certain whether we can be left what we've dealt with this in terms of the process now that we can't we await for the public hearing. Daksha?
Chair, I think we've sufficiently dealt with the process and we'll allow for the process to unfold and reconvene once the public hearing, once the public comments are received.
Can we get a sense when are we going to start with the request to make an application?
That would be immediately, Chair.
Okay.
After this meeting, we'll have to start the paperwork and set the wheels in motion.
Okay. Thanks very much, members. I think, Mr. Matons, is there any other matter?
Yes, Chairperson. Adam and I developed a draft advert that you would like to present to the committee, Chairperson, if you allow him to do so.
The draft advert?
Yeah.
Okay.
Alternatively, Chairperson, it's just to indicate basically that we've indicated what the process so far has been and what will be included in what will be called for, which is essentially public comments on all the submissions from the NCOP. I can actually go through the actual document, but essentially it's just calling an advert for further comments. And at this stage, we've indicated the end of January, but that is subject to when the Confort gives us the extension to. Should I still flight it, or is the summary sufficient, Chair?
I think the summary is sufficient, unless members want us to. Honorable, I can see your hand.
Yes, Chair. I think it'll be important just to see it so that because we don't need to go back to it, and remember that this is our last meeting, so that we are able to, by the time that date is confirmed, we can be able to just then release the advert. Thank you, Chair.
Yes, proceed, Adams. Mr. Salman.
Eddie, I'm having difficulty presenting the advert from my phone because my laptop had issues. Can you share the document from your side? I can't share Word documents, any PDFs.
No, I'm trying to share you. I don't know why it's not showing.
Through your Chair, right, Eddie, stop sharing and share again.
Yeah, I did that. I've stopped sharing. Are you able to see?
No.
Still not.
Yeah, but on my side, it said participant now can see your application.
On your side, is it on the screen, Mr. Matons?
Yeah, it's on the screen, and it also shows that participant can see the application.
Through your Chair.
Mr.
Matonsi, you must close this one, close that screen, open the advert, close the screen, and then stop sharing and share again.
Yeah, okay, let me just do that. Are you able to see something?
Yeah, now can proceed.
Are you able to see
I
it?
should be working for ICT now.
Are you able to see it?
Yeah, definitely, Honorable. Yeah, we can proceed, Mr. Salman.
Thank you, Chairperson. So the Portfolio Committee on Home Affairs invites stakeholders and interested parties to make written submissions on the proposed amendments for the National Council of Provinces on the Electoral Amendment Bill 1B of 2022. The proposed amendments from the NCOP have material changes that the Portfolio Committee on Home Affairs considered important to advertise to ensure that stakeholders and interested parties have a chance to make comments on the new amendments. With the introduction of the bill in January 2022, the committee first advertised the bill and held public hearings in February 2022. The committee then publicized and conducted in-person hearings across all 9 provinces. While deliberating on the revised bill, the committee requested the National Assembly for permission to amend certain sections of the Electoral Act that were not in the bill. Some of the changes proposed were then material to such an extent that the committee had to re-advertise for comments. The National Council of Provinces also had virtual deliberations on submissions. The committee is again re-advertising the relevant clauses and is calling for further submissions in this regard. The proposed amendments from the National Council of Provinces to be considered will be as follows. So I'm not going to read through all of that, but it's basically exactly it's a summary of exactly what was included in the NCOP submissions. And then please note that the submissions must be limited to the above mentioned proposed amendments, and the committee will not consider issues raised beyond this. The proposed amendments from the National Council are available on the Parliament website, or alternatively, you can contact the Secretariat. Submissions must be received by no later than 12 midday on Tuesday, 31 January 2023. All submissions should be addressed to Ms. Chibane, Chairperson of the Portfolio Committee, and marked for attention of Betty Matonzi. And again, indicating that date may be subject to change depending on when the court gets back to us, either sooner or later. Thank you, Chairperson.
Oh, thanks, members. That is the draft advert. Mr. Matonzi and Mr. Salmon, can we shorten the date of closing date, the days of submission?
We could, Chairperson. Minimum is usually 2 weeks, and indicating that the festive season break is going until mid-January. There's a likelihood that we will only need to advertise for 2 weeks from mid-January to end of January, but we'll stand to be corrected.
Can we then resolve, members, that once the court has granted us for a short extension, we'll then work to determine what will become the shortest time. We can deposit this discussion in with the legal team and also try to run it on Manco. I'm trying to work on the line submission of the IEC. Can we consider that approach?
Supported, Chair.
Will it be fine, Mr. Salmon?
Agreed, Chair.
Okay.
Agreed, Chair.
Thank you very much. Yeah, thanks very much, colleagues, for giving that note. Is there any other matter, Mr. Matonzi?
No, there's no other matter, Chair.
Okay. Thanks, honorable members, for the deliberations we've held on the issues. We are moving from here with those 3 issues we've dealt with. And I want to thank the minister and his team, the council, the DG. I want to thank Commissioner Miepza and all the commissioners and the executive and your legal team. I want to thank Parliamentary Legal Service and the state law advisors for making sure that we are able to resolve all the issues so that we have a proper bill once we've concluded it, but also to give more opportunity to our people to make contributions on this bill. Thanks very much. The meeting stands adjourned.
Chairperson.
Honorable Ross.
Sorry, Chair. Since it's our last meeting, may I just give a congratulatory message or a year-end message?
Your last meeting.
Yes, Chairperson, it's our last meeting.
Yes, Chair. Parliament's supposed to be rising today, but we have a special sitting on Tuesday.
Oh, sorry. We're on the mood of the extension and electoral deliberations. This was last meeting, is not anywhere. Can I invite Commissioner Mebza?
Chairperson, I don't know if there's really anything special other than saying best wishes to all of you, to yourself and to the members, to the minister and his team. These are difficult times. I share your view. Given the weight that this bill carries, I'm not sure these are going to be holidays truly. On our schedule, work has to happen, but we are grateful for all of the deliberations that seek to strengthen this piece of legislation, which is so crucial for the work that we do. Thank you so much. All the best for the holiday season.
No, thanks very much. Mr. Mamabolo, you are represented. You don't need to come in. Minister?
Yeah, Chairperson, as you said, I'm not really feeling like a holiday with the amount of work that is awaiting us. All I can say is let those who have got an opportunity to go and rest come back strong. But from what I can see here, we are going to be in touch with each other quite often, especially if by Monday we are going to submit something to the Constitutional Court. So let's keep in touch, but come January, let it find us ready to finalize everything. Thank you very much and goodbye.
DG, you're represented. Members, Honorable Ross, let me start by you.
Chair, if I may, I'll defer to Honorable Kanyile.
Oh, yes. Honorable Kanyile? Honorable Lizelle?
Thank you very much, Chairperson. May I take this opportunity then to wish everyone a blessed time with their families. May you have a restful time and come back renewed, strong and rejuvenated for all the work that will lie ahead in the new year. I wish to thank our Minister, our Deputy Minister and all our colleagues for the hard work, also our colleagues from the IEC. And I want to in particular thank you, Chairperson, for the way that you have steered this ship throughout the year. We had a busy year and we dealt with very important issues. But I do think as a chairperson, you were really always very fair to all of us, very accommodating. And I think that is a type of leadership that we must commend. So we thank you for that. And I want to especially also thank Mr. Matonzi and as well as Mr. Salmon for all the hard work and support that they've given to our committee. And yes, I feel a bit sorry for the minister because I'm sure he's going to be at the border. And I'm hoping that things will go well at our borders as well, and that we don't see the same struggles as we've seen during other festive periods. But I wish all the colleagues well and hope to see you all early in the new year. Thank you, Chairperson.
Thank you very much, Honorable Kanyile.
Thank you very much, Chairperson. Apologies earlier on, I had a problem with my device. I want to take this opportunity and thank you, Chairperson, for how you have led this portfolio from when you have took over up until today. We truly appreciate you and appreciate the Honorable Minister together with the Deputy Minister for always being available and attending to the portfolio committee. We've never had any issues when it comes to that. And over and above this, in ensuring that they help us to address all the issues that we are having. I'd like to take this opportunity to thank the DG, the DDGs as well, with all the work that they are doing to assist members of the community. I do know that there'll be a lot of queries that we are going to get now that people will be traveling up and down to meet their families over the Christmas time. We'll be having a lot of queries of passports. I know we are going to be in touch until we meet again. And thank you to the IEC. And thank you to the members of the portfolio committee in how we have respected one another and cooperated with one another in ensuring that we serve the people of South Africa. And I'd like to take this opportunity and wish each and every one of you a well-rested festive season, if we will be resting together with your family members. And I am hoping that we'll be available to meet as and when we are required to. Thank you very much for this opportunity, Chairperson.
Thank you, Honorable Mudise.
Thank you, Chair. Let me give Honorable PA on my behalf to make those comments. Thank you.
Pile.
Thank you very much, Honorable Chairperson. Chair, let me appreciate all of the sentiments shared by honorable members. But in particular, I think it's important to give credit where it's due. And in that, I must applaud the leadership of this committee under the whip and chairperson, Honorable Mudise, and yourself. And also to thank all of the stakeholders, departments, the minister, deputy minister, and honorable members from the opposition parties and all political parties. I must say that we've had quite good debates in this year, but also we want to remember those that have lost loved ones. And in this time that I know all other parties may have to rest and we won't, wish you well over the festive season and to come back in one piece in the new year. Thank you.
Thank you. I'm not sure if Honorable Tito or Honorable Mohale are in the meeting because I had been calling them. Okay. Mr. Njikela? Daksha?
Chairperson, thank you for the opportunity. Honorable Pillay has made it difficult for me to follow what he has already done. Chair, all that is left for us is to thank you for your guidance and leadership. If there is anything, hopefully we can still be able to reach out to you, even in this holiday period, if there are further guidance that we require. Thank you very much, Chair and honorable members.
Thank you. Ms. Govender?
Thank you, Chairperson. Chairperson, on behalf of the Office of the Chief State Law Advisor, Ms. Aisha Johar, Ms. Saraya Williams, Harriet Mekwa, and myself, Sarah Govender, we'd like to thank you for allowing us this opportunity to wish one and all a very blessed Christmas to those who are celebrating. And to all those who will be traveling, we wish you safe travels. And we will also like to place on record that we will be available during this festive period should we be required for anything that the committee may require. Thank you, Chairperson.
Thank you, Dr. Twalo.
Chair, I just missed what you were saying. Can you repeat yourself, please? Sorry about that.
I said Dr. Twalo.
Yes, but what you are requesting me to do, Chair?
There's an item of Honorable Ross on the table.
I completely missed that one, Chairperson. Let me just consult with my colleagues.
No, don't need to consult. We wanted to thank members. We're appreciating the work we've been doing in this committee. And we thank all honorable members, stakeholders, and your team, Mr. Salmon and Mr. Matonzi. I'm deliberately bringing you in because you are presiding, you are head of the team. That's why I'm calling you, but there's appreciation of the work that we've done, the weaknesses identified, have to close each other. But we are just doing this for record. As the last item or meeting, I was not even aware that it's the last meeting because of the matter we're dealing with. And I think all of us will agree that we still have to interact, must be ready to be called to deal with this matter even during the constituency period so that we come closer and finish up this process. is all our collective work on behalf of our people who have tasked us to interact with the laws of the Republic. That then will, I'm sure, Honorable Ms. Twalo, I thought you'll talk on behalf of Mr. Salmon and that Mr. Matonsi.
Oh, yes, thank you, Chairperson. I'm sorry I missed that one. I just had to move out and then come back as well. My apologies to you and the members for that. Yes, Chairperson, we are also very grateful that we were able to assist the committee right from the beginning when this bill was actually referred or introduced in Parliament. I think with regards to public hearings, the team and including other colleagues from the committee section who accompanied members to various provinces during the public hearings, I really appreciate that. And also during that time, the feedback that we received from the chairperson and also Honorable Pillay as a leader of the second group, I think we appreciated that. That could only serve to actually improve on what we were doing as well. And some of the things that members identified, we could pass them on to the other sections that are supporting this committee. And usually, Chairperson, with regards to public hearings, we have colleagues from other sections that are not really recognized when we come to the committee processes, but there is a big team behind the scene, working behind the scenes when it comes to public hearings from various sections like languages, like the public education unit, household services. All those people actually assisted us, and I would like to recognize the work that they have done for this committee. And of course, Adam and Eddie for the work that they have done in calling these meetings, writing of reports that eventually serve before this committee. I'm really, really grateful that they were part of that. And Chairperson, I must also say that they did not only assist this particular committee, they kept a track of what was happening in the NCOP as well, which is something that we don't actually often see, even with our colleagues. And I really appreciate that. And the team from Legal Services, we communicate every day with regards to this particular bill, and we're able to actually support this committee and advise the committee on what they need to do. I'm really grateful. Thank you so much, Chairperson.
Thank you very much, Ms. Twalo. I think we'll then be assisted to request permission from Parliament to proceed with our decision. And I hope we may, before we rise on Tuesday. Thanks very much. There's no lunch. Our meeting stands adjourned.